Okay, so in the interest of getting as much time as possible with the justice, I think we will get started right now. I want to thank everyone for joining us for our second in the series of the Legal Gold Rush. Chris and I are very excited to have everyone join the Legal Innovation Zone for this new series. It got kicked off last week with Jack Newton, and as you may or may not know, it's really all about talks, tips, and tools to help access what Chris and I call the 1 trillion unmet legal need market. So thank you once again for joining. Just as a reminder, these sessions are being recorded, and so if you miss anything or want to go back and listen to it, it is all available on our website approximately 24 hours after the session happens. We have everyone muted. If you figure out a way to unmute yourself, please do not do that. And most importantly, this is definitely an interactive session. So if you do have questions, please text them to Chris Bentley, and he will be reading them off as the conversation goes on. So without further ado, Chris, over to you.
Well, thanks very much, Hirsch. Welcome, everybody. Delighted you could join us. Really excited to have a conversation today with Justice Deno Himonas, who obtained his law degree in 1989 from the University of Chicago, worked for a period of time in civil litigation with a Utah firm by the name of Jones, Waldo, Holbrook, and McDonough. I'm going to ask you about that in a second, Your Honor. Was appointed to the 3rd Judicial District of Utah in 2004, the Utah Supreme Court in 2015. Welcome, Justice Himonas. We're delighted to have you here, and hopefully you and your family are safe. And are you practicing from the court, or are you judging from afar?
Judging from afar, Chris. So first, thank you. Thank you for the opportunity and to have this discussion. I'm looking forward to it. I'm not too far south from you all right now. I'm about 100 miles due south of International Falls, in our second state of Minnesota. So we're here with the whole family hanging out and just watching the ice go off the lake yesterday.
Oh my goodness. Well, welcome. We're delighted. And yes, hopefully warmer and better weather very soon. Just to cast your mind back to your civil litigation days, you worked with a firm as a civil litigator. Did you ever think of going off on your own?
There was a time, there was a brief period of time where I kicked around the notion of practicing with a few friends in a kind of a boutique firm, and ultimately I decided against it. I went back to the powers that be, and I told them I would stay, but I had 2 demands.
And what were those?
Well, I'm sure they thought that this guy's going to ask for a bunch of more money, but I demanded better coffee. So pretty much you'll see me with a coffee cup in hand at all time, and that they do away with the dress code, which in part explains why I'm dressed the way I am. I'm a notoriously poor dresser. One of my colleagues says that I dress like a carny. That's his polite description. So
I love it. Well, in this age of face-to-face Zoom meetings, it doesn't really matter too much as long as we can see and hear you. You see the face and hear you. I'm better coffee. That's got to be the #1 demand of many in our profession. You've become the leader of a movement to open up legal services so they can be delivered by entities, people who aren't lawyers. Why are you doing that?
I have a passion for access to justice and for narrowing the gap. And we've been in Utah and on the Utah Supreme Court, we've been working on trying to narrow the gap for years with a variety of projects. I'm proud of each of them, but this one is the game changer.
And what were the needs you saw that weren't being met? Why did you want to go to the game changer as opposed to starting another project?
So we have, there's nothing wrong with tinkering around the edges. I mean, the important changes and improvements are made in that way too. So I don't want to disparage those because they're extremely valuable. But sometimes just kind of, you really need to dynamite the logjam. And then you can start tinkering around the edges again once you've blasted through it. And that's kind of how I see our efforts at regulatory reform.
And when did the idea start coming to you that you needed more than tinkering around the edges?
It's one of the few times where I can tell you exactly where I was and when it happened. And it happened as a direct result of one of your own, a Canadian by the name of Gillian Hadfield, who
Yes, now at the University of Toronto.
Yes, and is just a superb and leading thinker in the area. In May of 2018, she was presenting at a conference of the Council of Chief Justices and Court Administrators for the Western United States. I was there with the chief from Utah as well as the president of the bar at the time, and I was presenting on some of our other access to justice issues, licensing paralegals, online dispute resolution, and heard Jillian's discussion, and that was it. The light bulb went on. We sat down as a group at that time and started charting how we were going to move in the direction that she had outlined during her discussion.
Now, in the United States, the Supreme Court has the superior courts, the Supreme Courts in the different states have effective control, and I'll generalize, over who can deliver legal services and how they can be delivered. In Canada, the law societies of the different provinces have control by statute. So when you broach this topic with some of your colleagues in different states or in your own state of Utah, how was it initially received?
It was an easy sell with my colleagues because the chief was there and with us at the time, and there are 5 of us, and surprisingly like-minded when it comes to this. So, all over the board in different aspects, but this is something that appeals to the left and the right, if you think about it, right? I mean, it appeals to the left because you want to improve access to justice. And who doesn't want that? It appeals to folks on the right because we're talking about a market-based solution to the issue. We've tried, and I mean, lawyers have generously volunteered their time for decades to try to narrow the access to justice gap, but we can't. I mean, it's the old Einstein adage about the definition of insanity is doing the same thing over and over again and expecting a different result. We have spent billions of dollars trying to volunteer ourselves across, and it's not worked. Not that it's not important, but if we're candid about it, and as we've measured it, it's not slowed the flow.
No, the problem almost universally seems to be getting, if anything, seems to be getting bigger rather than smaller, notwithstanding all the wonderful efforts that you speak about and so many of our colleagues have put in. What types of expertise do you think we need to assist in this endeavor? We've got lawyers and judges, but what else are you trying to unleash here?
Yeah, so that's a really great question. And it was kind of one of the questions we initially asked ourselves, because what's underlying that question is identifying the innovative force that you think might be most beneficial. And we actually came up with the answer of, we don't know. We're not the innovators. And we want to create an environment in which the real innovators and those forces can come to bear, rather than kind of steering in one way or another what we think the innovations and kind of powerful forces might be. So I think that's part of what underlies the sandbox concept for regulatory reform is we'll evaluate it. We'll let you come in, but we're going to be agnostic about where that innovation might come from, whether it be from a tech platform, whether it might be from having somebody who's not currently authorized to deliver legal services, right? Yeah.
But it's a bit radical for lawyers or judges to suggest that we don't necessarily have the expertise in certain areas, isn't it?
Yeah, so, well, it may not be a question of expertise, right? I mean, let's think about, there's at least in our area, a fairly prominent study out of the UK that has lawyers versus non-lawyers delivering legal advice and measuring the effectiveness or how that legal advice is perceived by the clients in terms of debt collection, landlord, tenant, housing. I mean, some of those critical needs areas. And what that study reveals is that lawyers, the solicitors, excuse me, about 25% error rate, 20% error rate. The same for the non-lawyers. But the stunner was on the other end. The non-lawyers that were giving advice in those areas were 600% more likely to be ranked excellent in giving excellent legal advice by the client. So it's not it's not a question of expertise. It may be a question of those individuals are just focusing on those areas, or because those individuals are able to deliver an equal product at a much lower price, they're more likely to be labeled as excellent. Not clear what the linkage is. But I think the problem, the point is not that the lawyers don't have the expertise. They're just not as special as they may think they are. Speaking as the lawyer, right? I mean, I get it.
Ouch, but true. Ouch, but true. So how are you going to do it? What's your approach in Utah?
I think we're going to be the first in the world to use the sandbox model that other industries have. It's most prominently been used in fintech. But the concept is, the sandbox is this idea that you come into a controlled space that's being supervised by experts. You offer the idea, you set up basically a pilot, a controlled experiment. You loosen regulations within that confine, that specific confine, and you test it. And you see if it really does deliver. If it does deliver, right, then you can authorize it in terms of the practice of law. If it doesn't deliver, shelve it, go on to the next one. But a lot of law schools and other schools are building design labs now on campuses, right, where they're bringing together interdisciplinary efforts. It's really that concept. And one of the fundamentals of that concept is to pilot. Okay?
And so you're going to have a real-time, real people pilot.
Yep. And we're starting. So on Friday of last week, we promulgated the standing order and rules to authorize this. There's a 90-day comment period. If I'm being candid about it, because that comment, I mean, the website that draws the comment and to whom it's advertised are lawyers, not looking for a ton of positive comments. We'll certainly get some, but we've steeled ourselves. Assuming that all goes according to Hoyle and we get it up and running, we'll be operational in July. In the meantime, my colleagues have authorized that we begin advertising immediately for COVID-related services. So individuals that are offering low cost or no cost COVID-related legal services, we will pilot immediately outside of the comment period. So piloting the pilot.
I mean, from what we've seen or heard in other states in the United States, when reform initiatives have been advanced, I suspect you're right that the comments from many lawyers will not be favorable, but you're prepared to move ahead anyway, unless you're going to move ahead anyway.
Well, I don't know. I mean, candidly, I'm hopeful. My colleagues have been very supportive along the way. So I hope that that's the case, but it's not. That's also not the same thing as saying we're not listening to the comments. I mean,
I understand.
for example, let me get a good example. Is 2 weeks ago we became the first state in the country to deal with the COVID-19 crisis by offering the diploma privilege. So rather than requiring people to take the bar exam, they would by graduating from a law school inside or outside the state with a certain pass rate, and then 360 hours of supervised service on an emergency basis. We did that. We announced that principle, but then opened it up for comment and made a number of, I think, really good tweaks to the system as a result. So there will be changes, no doubt, to the proposal as a result of the comments. I mean, we will read each and every one of those comments. Each one of us will read each and every one of those comments. And to give you an example, I mean, there were 500 and something in the week for the diploma privilege, and everybody goes through them. But I'm hopeful that it's just not a vote of the lawyers, right, that determines the outcome of this project.
So I can anticipate as you open this sandbox up, you're going to get some lawyers who want to work with business people, finance people, technologists in a different arrangement that involves ownership. You may get some pure technology business people who want to do this.
Yep.
You may get some people paralegals who are able to do some things in law and not in others. You may get some people from Canada who want to come down to Utah and participate in your sandbox. Is that allowed?
Yep.
Hey, Hirsch, I might be leaving soon.
Oh, yeah. So look, again, I think that's the point about the sandbox being agnostic. We're both what the platform or the form of the provider. We'll sit down and listen. If you go through the standing order, I think it's really interesting. There's a single regulatory objective. There are 4 or 5 regulatory principles and a single regulatory objective. And, the goal is to benefit the consumer, right? And it's to put the interest of the consumer above the interest of the profession.
Does Utah have a strong, vibrant tech community?
Does. Very.
You're going to get a first mover advantage in this for that tech community and all those interested in investment, aren't you?
Not lost on us. Yep.
And they'll be able to sell to other consumers in the United States.
Maybe, maybe not. I mean, they'll be able to certainly take advantage of regulatory reform in the U.S., as will firms that are located there. We're not alone, by the way, in this venture, as you know. I mean, Arizona is simultaneously proceeding. They're using the path that's much more similar to that was used in the UK and in England and Wales, rather than the sandbox model, which is one of the things I love about this. I mean, this is an experiment. And I should be clear about that from the outset. This is, in Utah, this is a 2-year experiment. We're being evaluated by 3 outside groups. There's the old Ronald Reagan adage about trust but verify, and that's we've kind of taken our own advice about making this data driven to heart. So we'll have outsiders evaluate this and making sure that we're actually improving access to justice and delivering to the consumer rather than just talking about it. And if at the end of that period, that's what's really happened and it's been beneficial, then it's time to make it permanent. But those, I should say, that participate in the meantime, they'd be grandfathered in. I mean, we don't expect anybody to participate on just a 1 or 2 year basis.
So if you're approved for the sandbox, you work, unless you're thrown out because you're incompetent, you're going to be able to continue.
Well, it's not just a question of competence. If your product doesn't actually deliver, right? I mean, we're looking at benefits and harms. If it's not helping, if it's hurting, if it's not meeting our regulatory objective, there's no reason to license it, to authorize it. But we want to deliver, good, efficient, affordable legal services to the public writ large.
And I know you mentioned you've already opened up for COVID-related services. You mentioned fintech, you mentioned privacy, but there's no limit to the areas of legal service delivery that your sandbox will entertain, right?
Nope. That's right. That's right.
So,
Again, our based on, I mean, it's anecdote, not data right now, but based on those anecdotes, we anticipate a number of providers that will be focused on improving access to justice, and the interviews that we've had early on with interested parties have borne that out. So we'll remain agnostic. If at some point in time it looks like that's not the case, right, then we can put our thumb on the scale in a more direct way in terms of trying to guide them to the real access to justice issues.
what about consumers and consumer protection? How are you going to go about protecting consumers?
Well, I think that this is great. That's a great question, and I think that protecting consumers based on actual data is a lot more effective than protecting consumers based on prescription alone, right? A lot of the rules there that are built into the rules of the profession, at least here in the States, people being candid about it will acknowledge they're really protectionistic measures. They have little to nothing to do with advancing consumer interests, and were adopted in a way that, I mean, explicitly to protect the legal profession. The story about the ethics kind of arose after the fact, and the outside ownership example, I think, is just a prime example of that happening.
Well, let's talk about that, because we have those same restrictions in Canada, that if I'm a lawyer and if I wanted to set up a legal service delivery firm with Hirsch, who's the entrepreneur, I can't do that in Canada. I can't do it in Ontario, because even though I'm said to have far superior ethics as a lawyer, my character is apparently so fragile that it will dissolve.
Yeah,
there's no evidence for any of that.
No. Right. I mean, there's just not. And a perfect example is, I mean, the LSA was adopted in 2007, right? And we've seen alternative business structures in England and Wales for a long time now. There is zero increase, as I understand it. And from the evidence that I've seen, the notion that there's an increase in bad behavior, in disciplinary measures, those types of things. It's just not there. And that makes sense. I mean, look, I practiced for a long time before do I really think that I was getting less economic pressure from my partners than I would have been getting from Hirsch? And that's just nonsense to me, right? It's just utter nonsense. You're getting it anyway, and people say, well, the VC's this and the VC. It's just not borne out. It's not happened.
There's no evidence anywhere in the social sciences for the suggestion that lawyers have superior ethics or inferior character.
No, and as our friend Crispin Passmore likes to say, he's not met a lawyer yet whose ethics are so weak that because they've rubbed shoulders with somebody who's not a lawyer, suddenly they dissipate. Look, and the rule, if you've looked at our 5.4A and B, those same fundamental values are still there, right? You're required to meet that duty of loyalty, the duty of confidentiality, and if you're talking about a business arrangement for whatever reason, you can't guarantee that, right? Then you can't have that business arrangement. That's fine. But that as opposed to just banning all business arrangements across the board seems far preferable, right?
So you've not reduced any of the lawyer duties in
Nope.
creating this sandbox.
Nope.
You're holding them all to the same high standard.
Same fundamental values are expressed in our new 5.4A and 5.4B, right? Those are things that even though while we easing up restrictions, so while it's easier to advertise and solicit, fee sharing is easier and fee splitting, those types of things, all within the confines of your fundamental duties. Right? So you have an obligation, and we're going to measure that obligation. But what we're going to stop doing is saying that just across the board prescription is the right tool. It's a it presupposes that every ethical problem is a nail and it needs to be a hammer.
So I want to flip the question around a little bit and say, look, let's assume that I'm a young lawyer and haven't been in the profession for 40 years. And I've spent a huge amount of time. I've spent a huge amount of money. I'm at the early stage of my career, and you're ending my monopoly. And that's great in theory, but from my perspective, it doesn't sound too good. Where's my future? What do you say to that? I know it's selfish, but look, that's me. I spent this time thinking the landscape was going to be in a certain way, and you're changing the rules.
So let me first, most young lawyers that I've talked to, Chris, are more supportive than those of my vintage, but separate story. Let me just take the hypothetical as it is. There's no evidence that with the ABS you're going to see a reduction in lawyer employment or numbers. And again, we've followed and can follow the trend in the UK and watch it increase at the same rate, right? The delta has been constant. So empirically, that hasn't happened. And you have to ask yourself, okay, well, why is that? Right? Well, because we're talking about, in many ways, talking about offering services to folks who aren't going to lawyers to begin with. Right?
We're talking about the unmet legal need.
An enormous market. And one of the benefits of this for lawyers is, and I can give a couple of examples of helping lawyers access this this market, right, in an efficient way, that it's now affordable, that it wasn't before. So you start thinking about it in those terms, right? Then it starts to make sense, and you can understand why that growth curve has remained constant despite the ABSs, right? And the last is, all right, if you're not going to accept the data, right? If you're going to reject the linkage, and you're going to let me just accept the premise that lawyers will be harmed. My message is clear. Look, if some lawyers are going to make less money as a result of improving access to justice, then so be it, right? Then so be it. That's just the way it needs to be. It is anathema to me to suggest that we put our interest above the public's interest. And to the extent that regulatory agencies like the court or bar associations have been putting the interest of lawyers above the interest of the public, then it's time to pull back those powers and that regulatory authority. Right.
So I think I want to come back to the point that you made at the beginning of this about the lawyers, the less experienced, the younger lawyers that you speak to are actually much more open to change. Let's talk about that a little bit.
Yeah, I think we all recognize that the generation or two behind us are much more tech savvy, and they expect they anticipate and expect that the way tech has impacted other aspects of their life, that's the way it should be in other professions. I mean, banking. Think about the ability to take a picture of your check and have it deposited. Those types of things. There's no aspect of our life, and I mean that literally, that has not been impacted by the explosion in technology, from you name it, from how we take care of ourselves to how we conduct our purchasing activities, to religious services, to whatever it is.
So if I'm speaking to that group of younger lawyers and they're worried, understandably, your advice to them?
Well, start thinking that the bar associations and others, and what we really need to do is help them understand how they can benefit from this. And it's one of the things that we've started focusing on. is showing them the advantages, and not just young lawyers, but lawyers of any vintage, right, that are willing to innovate, that are willing to try. There's some really good examples,
and they're founded in that unmet legal need that that the Legal Gold Rush series is all about, that you've identified in Utah, that seems to be in many parts of the world.
That's right.
Which really is an opportunity as opposed to just a title or a statement. When we talk about unmet legal need, what are we talking? We're talking about people with no money who can't access legal services, or small businesses that can't access legal services. We're talking about lots of different situations.
Yeah, I mean, a good example is, if you think about in trust and estates, there's a huge number of the population that doesn't have a will or a trust. And it's expensive. Having just completed one, right? It's expensive. So, spend a couple $1,000s to go through this process. But most people don't need to spend a couple of $1,000s. You can develop a product that you can offer online at but if you want to hit the masses at 25, 50 bucks, $100 a shot, whatever you want to make it, and just with a little AI built into the platform, it'll direct you to, right, if you have a special needs child or something where you really need a very specific kind of will, it'll send you off then to that lawyer and supply it. But that 80% mark that doesn't have one or needs it updated can suddenly get it. And that's another experiment that they ran in the UK that I'm sure you're familiar with, where they found an error rate for those that were up 25%, and then found in secret shopping programs with the lawyers an error rate of 25%. So you're offering a product that's not harming the consumer, at least as you benchmark it vis-a-vis the wills that they're getting anyway, but at a far lower cost. So I think that's to me, that's akin to what we've seen with some of the finance technology. CPAs haven't gone away ever since we started offering, QuickBooks and everything else and other ways, TurboTax. Guess what, right? That the same kind of concept. They're still there. They're still there in force in the same numbers. And that kind of, right? It's opened up the ability for a lot of people that wouldn't use a CPA to file their taxes in the first place to do it.
And the data, you keep coming back to data and measurements. As you set up your regulatory sandbox, you're going to be gathering data.
Internally and externally. So externally, the National Center for State Courts is going to be studying the program. Professor Anna Carpenter at the University of Utah Law School and her research colleague, Dr. Alex Marks, an empiricist at Wesleyan, will be studying it. And if I understand it, Pew is in the process of working with the Pew Foundation with the Institute for the Advancement of the American Legal System to fund yet a third study. So independent outside evaluators. Internally, we have Dr. Tom Clark, who is retired. Dr. Clark is one of those horrible retirees. He was the Senior Vice President of Innovation Technology at the National Center for State Courts. He's an economist and really well known in the access to justice space. That'll be helping. And then we have the person who I would say is probably the most well-recognized voice in the access to justice space, certainly in the United States, if not across North America, the world. Her name is Rebecca Sandifer, Becky Sandifer. Becky Sandifer is MacArthur Genius winner. She's a professor now. She's just moving to Arizona State, professor of sociology, the editor of the Journal of Law and Social Science, I believe. We have, world-class data evaluators that are helping us understand this program.
And will the results of their analysis, their studies, be made generally available, publicly available?
Yes, they. I will break my pick to make sure that these are publicly available. I'm interested in transparency, and I'm interested in trying to do the right thing. If this program really doesn't work, then the program needs to be put to bed, right? I'm optimistic, I'm confident, but I want, like I said at the beginning, we need to take our own advice. We need to make decisions based on data. And if it is successful, if we can measure an improvement, we can show that the consumer is not being harmed, we can show that the lawyers aren't being put out of business, right? All these different metrics, right? Then we have something.
Remind me or let me know, in Utah, is court data and government data generally available to entrepreneurs and startups?
No, court data, because of the nature of the data, we generally require, data sharing agreements. So it really depends, I think, in your definition of data, but I think at the level that we're talking about, data sharing agreements are typically required before you can access them, right? So they've not monetized them yet. Now there's a big push for that. I think that some liberalization of data policies is coming. Right.
Interesting. Now I know you can bring the sandbox in without the majority approval of senior lawyers, bar associations, but what strategies do you have to address those voices, the ones who have traditionally been opposed to a lot of things?
So one of the great things about this is the way it started in Utah was the then president of the bar was with us, and he's been my co-chair on this program all along. An individual by the name of John Lund. And John's successor, who became the president of the bar, also became a member of the work group. And it was actually the bar that wrote the Supreme Court and asked the bar to undertake the study. So the evaluation that took place included the past as the co-chair, immediate past chair of the bar, general counsel for the bar, the head of the bar's innovation services, right? Heavy bar influence from the very beginning, and I credit our state bar for that. We have worked collaboratively on lots of different A2J programs, and it's been people like John Lund who've exhibited that kind of courage and leadership that have made this possible. And that on our work group right now, the new head of the bar, who will become the president in July, is on that work group as well. We've tried to work as closely as possible. That is not to say that there has not been bar pushback from both bar leadership and bar membership, right? But it is to say the bar's been given a voice, and that there are important leaders in the bar that have been pushing for narrowing the access to justice gap by basically any and all means.
So in a number of jurisdictions, we've got very senior members of the bar who are adamantly opposed with their associations to the type of opening up that you are about to engage in Utah. What do we say to them?
Same thing we say to the young lawyer, right? If all you're interested, if what you're saying is, you're going to destroy the profession, right? The collegiality, that notion, I say that generation is gone to begin with, right? And that is no excuse for, that's not a justification for having consumer unfriendly business practices, investment practices, so that you can maintain kind of, some Norman Rockwell version or vision of you being a lawyer. I also think, as I said at the outset, it's just not true. I mean, we always start with the data points. We always start with, talking about what the studies have reflected. But at the end of the day, that's the same message. You cannot use that as a justification for the kinds of limitations that the vast majority of the citizens in the United States, and I dare say Canada, are facing, right? I can't afford to hire a lawyer for real litigation. Let's be honest about it. I mean, unless you are a 1%er, we're talking about a gap that runs the socioeconomic gamut, right? who could really, I mean, really afford to invest $1 million or $500,000, whatever it would cost for serious litigation these days, out of their own pocket, and potentially pay legal fees on top of it, and no guaranteed return. I mean, it's just
it's just not gonna. It's not.
it's not true. It just doesn't happen. It's right.
And I'd encourage any listeners, if you have any other questions, please fire them along. This is it's really interesting as you start this sandbox, and the start date will be, when is the start date? Assuming you go ahead with it.
Right. So if everything, again, as I said, everything goes as we anticipate, then the sandbox will be up and running for business full time in July. But starting to encourage people right now that have low cost or no cost COVID related services, to start, expressing their interest. We've spent, so I want to just hijack the conversation for just a second, if I can, Chris. We've spent a lot of time focusing on the technology, I mean, as we've talked about it, but I want to highlight that it's not just, the sandbox isn't a way to just technology. It's also a way to test who actually delivers the legal service. So let me give you an example of what I'm thinking about, and what I've been talking about is an example. I've been proposing that a bunch of law students, let's say Professor Carpenter's law students, trail some social workers in the field for a while. And they gather a bunch of questions that those social workers are asked, right? And then they turn around and they go back to class and they do a little triage, and they figure out which of those are legal questions, legal related. And rather than saying it's a crime or that it's punishable by a fine, or civil violation for a social worker to answer that question, what if at the law school we built a class, right, a practical course that would educate people getting their LCSW or MSWs in social work in those questions? And so long as they didn't charge for it and they offered it in good faith, immunize them from malpractice for that. So those first responders, those community first responders, some healthcare workers, social workers, librarians, right? We're talking about testing that, something like that. And there is no way somebody is going to convince me that the person that's asking the social worker question about how they could best get their protective order filed, right, that's costing a lawyer any amount of money whatsoever. But it's delivering an immense improvement, I think, when we're talking about community first responders, right? Access to justice. Lots of folks just have simple legal questions and needs that they want answered. Right? And the librarian, when they come to the court, that has to say, I'm sorry, right? Now you've asked me a question that would qualify as legal advice. I can't answer that, even though they know the answer. The answer is obvious, and that's all the person really needs. And I shake my head.
So if I'm, no, that's a fantastic example. If I'm a business person and I don't want to do it for free, I want to answer the employment HR questions that many small business people have. I've got experience in business. I've dealt with this. I don't have a law degree. I don't have any credentials, but I think I know the 50 or so questions we're going to get asked all the time. And I want to say to business people, well, you know what? We'll charge you $200 a year as a subscription. When you get a question, give us a call. One of our people will give you the answer to most of the questions. Let's just assume that for a moment. I want to start this up in Utah. What's the process for me to convince you to be part of your sandbox?
Oh, so you'd make application to the sandbox. We evaluate it, and then sit down, right, and understand exactly the mechanics and what you're talking about, what data needs to be gathered, benchmark what exists right now, and then test over some discrete period of time, discrete number of people, right? How that works, or test your algorithm. Let's see. I mean, maybe you're offering this through bot technology online, and you've got those questions worked out. We can test that. We can see if those answers are accurate. I mean, what you're talking about really is pretty common, right? I mean, I'm thinking about. Is it Rocket Lawyer that I mean, you can call, right, and you'll get answers through, I think it's $45 a question, something like that, or $45 a month, is it? And I'm not sure what the fee is, but and you can have an unlimited number of questions then, or $45 a year, perhaps. I'm not sure what it is, but right. But they'll also, so you can use kind of guided technology. The bot can answer these questions. If they can't answer that, you can go off to lawyers or non-lawyers. At the end of the day, it's going to send you off to, depending on the nature of the question, to a lawyer if it requires a lawyer, right? But I mean, everybody needs, to quote Professor Sandifer, everybody needs and deserves legal advice. Not everybody needs and deserves that advice to come from a lawyer.
And in my example, if I was never going to send them off to a lawyer, except in the rarest of cases, because I've developed a database of questions and answers that are based on studies, and we can show that to you. I wouldn't be prohibited because I'm almost never sending them off to a lawyer, but you'd want to see what I was going to be doing.
Yeah. No, we would not want to see, we would see.
Yes.
And we would validate that you are right. I mean, that this is not harming the consumer. It's improving the consumer's lot vis-a-vis where we find them. I mean, we don't want to benchmark against perfection, because that's not what exists right now. We want to benchmark against, right, what consumers in that specific area are actually getting. Right? And if you're improving it, you're giving them quality legal advice, right? It's affordable, it's helping the consumer, however we want to measure it, great.
And it's interesting, in several of your examples, you've referred to the UK study, for example, where you're measuring error rate between the non-lawyer providers and the lawyer providers, or the solicitor providers in the example you gave. So you have, not measuring against perfection, you have real life examples by the solicitors against which to benchmark.
Yeah, look, you've got to properly benchmark if you're going to measure things, right? Because what are you measuring against?
One of our questions says, exciting initiative, makes so much sense. What about courthouse staff, where you get somebody who comes in the pre-COVID and hopefully post-COVID days, who comes to the counter, they don't have a lawyer, they've got the paperwork, and there's a gulf between information and the type of simple advice that will allow them to actually accomplish what everybody knows what they need to accomplish. Get the darn paperwork filed and get on with it. But the courthouse staff, at least in Ontario, they're not allowed to give that type of advice.
Yeah, that's right. So, you know, maybe because you're concerned about creating a problem with the appearance of impropriety, you keep that curtain where it is. But those individuals are there then trained to send them to the law librarian that has now been opened up as a result of what we talked about. Or they're given the number to the self-help center, which has now been opened up to give legal advice, which they couldn't give before because of what we've talked about. Or maybe we lift the curtain a little bit. In fact, we did that in Utah when we're talking about online dispute resolution in our pilot program. One of the things we did is we brought in facilitators, non-lawyers, lawyers, right? But authorized them to provide procedural advice, not substantive advice, but procedural advice to both sides. And what we're talking about is, you know, helping them exactly what you're talking about, fill out which form. And this is limited, by the way, to small claims court where we're doing this. It's not where almost nobody is a lawyer, right? So you might choose that particular route. So I could see from, you know, a partial lifting. I don't know that I can actually see an entire lifting because of the need to preserve the appearance of fairness, right, from the judiciary, and the clerk may be just too closely tied to the judge. But you can certainly open up, including in the same geographic space or on a platform, that same advice. And I think we're seeing I think it's in Alaska, Georgia, and in Tennessee, where they've been training community first responders in making the correct referrals. And I'm told that there's been a real improvement in those areas.
It's interesting you refer to them as first responders, because we don't often think of people entering the justice space as the first responders.
Yeah, I call them community first responders, right? And those are the people that I mean, we kind of on the ground that we first go to, right? It's again healthcare workers, social workers, librarians, religious leaders. I neglected to mention,
Yep.
right? That you call
The you know, in Ontario, we have a very vibrant legal clinic, community legal clinic group, more than 70 of them. And what you would be doing is greatly expanding their ability to provide advice.
yes.
Provide the type of that community first response assistance that so many would need, either in person or interactively online or by whatever means possible. And in many of the examples you outline, you're talking about exactly that: librarians in courthouses, social workers.
Yeah.
Coming back to the economic opportunities so if let's say I'm the Minister of Finance in Ontario, or your equivalent in Utah's government, and as economies get going again, and governments are usually should be focused on economic activity, good jobs for people in the community. What's the economic pitch? Leave aside the purely legal pitch. What's the economic pitch for that Minister of Finance, the Treasury head, the people who are focused first and foremost on jobs? What's the pitch?
Well, it certainly outside investment is going to grow the legal community in Utah, right? I mean, a lot of these companies suddenly, if they find their ability to use their platform in a space where they're not violating, any kind of restriction, are going to move that platform here or invest here. The threat of the big accounting firm, if it comes in, opens its practice in an area where it's not operating outside of the law. I think currently they're doing that because of the ABS structure in England. They're currently doing it out of London.
Yeah.
That's their play. So I think if we're talking about the economy as a whole, and particularly its impact on the tech industry, and as I said, so Utah has Silicon Slopes, a very, very vibrant tech industry. It's pretty easy to sell economy-wide.
So you're going to have entrepreneurs who've been looking for an opportunity to develop their legal product, move investment to Utah. You're going to have the big four accountancies. They're going.
Not sure. No, so I would say the big four accountancies, I'm sorry to interrupt you. I doubt they move.
Okay.
Just not big enough, to be honest with you.
But the entrepreneurs will.
Yeah, certainly. But I again, and I hate using the word anecdote when so much focus is on data, but anecdotally, I suspect we won't see the big four. Now, if California decides to follow suit and pursue their sandbox model, it's a different story.
But you are expecting that investment will flow in. It will flow into some law firms that want to develop their areas. It will flow into some other entities. That's going to create jobs, probably a thirst for more lawyers. You're going to see a net economic benefit that will work with your existing tech industry and help expand that into the legal sphere.
Yeah, you see that kind of influx of capital that we're looking towards. I think that's the inevitable result, right? And
I wonder
open
if
up.
Yeah,
Sorry.
Go ahead.
I would just say open up technology and the ability of those innovators to hit this space. There's a individual who's running the design lab at Brigham Young University's law school, and he gives this really great example of they developed at the design lab at BYU a product for respondents in debt collection cases, where that respondent can use that technology, will help populate the answer form through bots, right? That, as I understand it, that technology has now formed the basis for entrepreneurs for a major multi-million-dollar venture, right? That has been acquired by a major California firm, starting as an access to justice tool. But by introducing that tech component into it, I think we're going to see, I think, a lot of that kind of garage innovation that turns into a really profitable, potentially profitable app or other solution.
So last question, and without revealing the person, let me say it comes from a judge. What are the benefits of this to the judiciary?
So let's, as a longtime judge and somebody who was at the district court level, where I have so many. I'm so excited about that question. Right? There is nothing worse, from my perspective, as a judge, for example, than to have pro se individuals in a divorce case. Maybe both parties are pro se. Because what happens?
Yeah.
Yeah. So what happens is unrepresented parties, right? Is they maybe they're getting along and they just submit their paperwork. That paperwork is wrong. It goes back. It's wrong. It goes back. Finally, I bring them in for a hearing because that's the only way this is going to get done. Or they're going to get frustrated and go away. Or they go on a default calendar and then have to come in that way. Or maybe even worse, they're actually litigating it pro se. But to offer the ability for them to be represented by, paralegals, which we do in Utah, and correct me, but you do the same in Ontario.
Not
right?
in family law yet. They've been fighting
Okay,
it for 10
we
years.
do it in family law, right? So that advantage, right? Or to have their forms correct from the outset because they've accessed this platform. So you don't have, the 3 hearings or don't have to have somebody pro bono help them out. I mean, I could sit down with that judge and if she bought me a beer, I could go on for a couple of hours with things that I've thought of. So
I have a funny feeling you've got your beer. I have a funny feeling you've got your beer. Lots of interest there. Your Honor, you talk about access improvements, better results for consumers, increased economic activity in Utah, benefits for the judiciary. And I just can't think of any reason to say no.
Well, but maybe I don't want to be caught drinking my own bathwater, Chris. So that's why we study it, right? That's why we take our fundamental advice of studying this. We run this as a pilot. We see if it's true. We don't evaluate it ourselves. We have independent, ethical, outside evaluators tell us if it worked. We make that material public, completely transparent. Then we make a final decision. I think I'm right. I hope I'm right. I've told you before, right? I'm investing a ridiculous amount of money in sending my daughter to law school right now. I wouldn't be doing that if I thought I was destroying the profession. But
well, on that note, best wishes to your daughter. Thank you so much for your leadership, for your comments, for your advice and suggestions. And yes, final decision will rest on the evidence.
yes,
thank you so much, Justice Himonas.
Thank you, everybody. Goodbye.
Bye-bye. Over to you, Hirsch.
Thanks, Chris. Justice Himonas, thank you so much. Utah has always been very, very high on my list, considering the Karl Malone, John Stockton days, great skiing, and the Tabernacle Choir. And this is just one more reason why I should get back to Utah very, very shortly. So thank you very much for all of your work. I know I appreciated this conversation. I hope everyone else did. As I mentioned at the very start, if you want to come back and see it, it will be up on our website. And next week on Monday for our Legal Gold Rush series, we have Christina Blacklaws, the immediate past president of the Law Society of England and Wales, will be joining us. So another fantastic speaker, a hard act to follow, but I'm sure she will do fantastic. So thank you very much, Justice. Thank you all for joining us.
Healthy and well, please. Goodbye.
Bye.